Welcome to the latest episode of International Law Chats, or ILC for short, podcast from the American branch of the International Law Association. The podcast airs on the first Monday of every month, and we hope you can join us each month for a new episode. I'm Chiara Giorgetti. I'm a professor of international law at Richmond Law School and a non-resident faculty at the Vienna Diplomatic Academy.
And I'm Milena Sterio, a professor of international law at Cleveland State University's College of Law and also managing director at the Public International Law and Policy Group.
Today, we are very pleased to be chatting with Cordula Droege, Chief Legal Officer and Head of the Legal Division of the IRC. Dr. Droege leads the ICRC's effort to uphold, implement, and develop international humanitarian law and its work on humanitarian disarmament. She's deeply involved in the ICRC's operational work through dialogue with the warring parties about respect for the rules of war. And she and her team work on numerous multilateral efforts on international humanitarian law, for instance, the development of a treaty on autonomous weapons system, international discussion on artificial intelligence in armed conflict, or the global initiative to galvanize political commitment for international humanitarian law. Welcome, Cordula.
Thank you for having me.
I would like to begin by asking about the mandate of the International Committee of the Red Cross. Now, the ICRC occupies really a unique position as both a humanitarian actor and the guardian of international humanitarian law. Can you explain a little bit to our listeners the role of the ICRC and how do you see that dual identity holding up today? And more specifically, maybe, how can neutrality be maintained in new forms of warfare that we see now in this very day in this highly polarized world?
Thank you. And I think you already phrase it so well when you say the dual identity of the ICRC. You know, we are a humanitarian actor on the ground, as well as what is often called the guardians of international humanitarian law. And so to start with our role as a humanitarian actor on the ground, we are present in over 80 countries in the conflicts around the world and other situations of violence. We have big operations in some of these countries. Our biggest operations are, for instance, in Israel, the occupied territories, Lebanon, Ukraine, Syria, Myanmar, and other places, Sudan. And we have today around 130 conflicts classified. Of course, that doesn't mean in 130 states, because you can have many conflicts in one state, but you have about 60 states being involved in conflicts. You have 300 million people, according to OCHA, in need of humanitarian relief, so who can't look after their own needs. And you have about 200 million people in areas that are either controlled by non-state armed groups or are contested between non-state armed groups and states. And so the ICRC really tries to bring what in the Geneva Conventions is called protection and relief. Today, often we talk about protection and assistance to people in these conflicts. We try to be very close to the front lines, to where the greatest needs are. We try to bring the relief to those people who need it most. We also, of course, have a very specific mandate to visit people who are detained in relation to armed conflicts and other situations of violence. And so we visit hundreds of thousands of detainees around the world every year. And again, we try to, in simple words, alleviate their suffering. And perhaps that brings me to the second part of the second pillar of our mandate, which is the legal pillar of the mandate. And the basis for this is that the suffering of people in armed conflict that I just described would be lessened if the parties to the conflicts actually did respect international humanitarian law much better. And it is their responsibility to respect international humanitarian law, but states have given the ICRC a mandate specifically to work for the faithful application of international humanitarian law, for the dissemination and understanding of international humanitarian law, and also for the preparing the development thereof. So, for instance, like we did for the Geneva Conventions or additional protocols. And so these two parts of our identity are always complementing each other. What we do in terms of our legal work, of our positioning in the law, of our research on the law, is always grounded and nourished by what we see on the ground and the problems that we seek to address on the ground. Now, your second question is a question about neutrality, and perhaps for the listeners, the ICRC and other the whole Red Cross and Red Crescent movement works on the basis of some fundamental principles, and perhaps the three most important of these fundamental principles are the principle of humanity, the principle of impartiality, and the principle of neutrality. Humanity, I don't need to explain, I think. Impartiality is a principle whereby we provide relief and we bring relief to those who need it most without discrimination and on the basis of needs. And the principle of neutrality requires the members of the Red Cross and Red Crescent movement not to take sides between warring parties. And that is a principle that comes under strain every so often, is in fact perhaps permanently under strain and always has been so. Because fundamentally, every human being will have most of us will have the reflex to say, well, you cannot be neutral between the perpetrator and the victim. You cannot be neutral between the aggressor and the victim. How can you be silent in the face of war crimes or genocide or crimes against humanity? And there, I think, we have to explain that the principle of neutrality that we follow is not a moral principle. It's an operational posture. And it serves the two other principles that I was just talking about. It serves our purpose, which is to reach people behind the front lines, behind bars, and that requires us to speak to all sides of the conflict because the victims of conflicts are on both sides of the front line. And so those who have control over them, those who can actually influence their well-being, are our interlocutors. We need to speak to them in order to lessen the suffering and in order to improve the situation. It requires us to speak to all parties, and so it requires us to build a relationship with them. Our purpose as humanitarians is never to close doors by denouncing. It's always to open doors to start a dialogue on how to improve the situation. That's what the principle of neutrality is. And it is very ill understood. It is often resented and very understandably, I think. But I think states are also would be mistaken to think that they don't need a neutral actor in the highly polarized world that you just mentioned. You were just saying the world is highly polarized. And so, in fact, warring parties and all states actually have a strategic interest in still having some actors who talk to all sides, who can find humanitarian pathways, who can find solutions to humanitarian problems, which require both sides to actually find agreements, be it on returning detainees to their families, be it on returning mortal remains, be it on extracting people from, the deepest jungles in order to bring them somewhere where they can actually negotiate, ceasefires or perhaps even peace agreements. And that's why a neutral actor like the ICRC is not only needed for operational humanitarian purposes that we find, but it is actually a strategic asset as well.
Many thanks, Cordula, for that comprehensive answer. Now, I would like to follow up and focus more specifically on the Geneva Conventions today. The Geneva Conventions, as I'm sure many of our listeners would agree, were crafted for a different era of warfare. Where do you see the greatest pressure points today, particularly in relation to non-state armed groups, urban warfare, and emerging technologies? And could you also tell us a little bit more about the updated ICRC commentaries and how they're used?
Okay, it's a long question. I'll try to answer it in two steps, perhaps. You were saying the Geneva Conventions were drafted for a different era. I think they were drafted in a different era, but they were drafted for all times. And I think they are timeless and have withstood the test of time. Why? Because they embody very fundamental principles that protect human dignity, that prohibit torture, that prohibit arbitrary detention, that prohibit sexual violence, which are protections that you need at all times and in all types of armed conflict. Also, I think we need to not think of the Geneva Conventions as something static, or indeed the whole body of international humanitarian law as something that has stood still since 1949. Of course, you have a whole body of international humanitarian law that has evolved since 1949 through treaties, such as the additional protocols of 1977, but also many disarmament treaties like the prohibition of landmines or cluster munitions, as well as customary law, with all the jurisprudence of the international tribunals, national jurisprudence, as well as state practice. So the body of law, the body of international humanitarian law that we have today has to be seen as something much more comprehensive than the Geneva Conventions drafted in 1949. And so are there challenges in today's conflicts? And you mentioned specifically urban warfare, non-state armed groups. I think in terms of non-state armed groups, of course, you have the asymmetry of many non-international armed conflicts that poses real challenges. But again, the foundational principles are now, first of all, accepted to be applicable to all parties to the conflict equally. And they are also principles and rules that we oppose to all these parties. We hold all parties to, the prohibition of torture, arbitrary detention, and so forth. And the question of urban warfare, I mean, when the Geneva Conventions were drafted, many cities around the world were still lying in rubble because of urban warfare and urban bombing, the bombing of cities. So it is not exactly a new phenomenon. What I think has always evolved, and that's the story of armed conflict, is new technologies. And you will always have new technologies coming onto the battlefield. And they do sometimes create questions about how do we apply the rules to these new technologies. And that's certainly something that we see with cyber warfare, where, all of a sudden what is attacked is not perhaps, hospitals, but what is attacked is the data of patients, or it's not the banking building, but the banking data. And so how do we protect this? How do we also protect people from operations that contain harmful information that is exponential, of course, compared to the harmful information that has always existed in armed conflict? So you have all these challenges, and I think most of those have been or are being answered through the interpretation of the Geneva Conventions and the rules of international humanitarian law in contemporary armed conflicts. And that leads me perhaps to the second part of your question about how do we use the Geneva Conventions today. And I think it's very interesting that the Geneva Conventions, again, are largely, except for Common Article 3, made for international armed conflicts. But of course, many of the concepts that exist in the conventions also are applied in non-international armed conflicts, and warring parties and states very often consult the commentaries to the Geneva Conventions to think about the concepts. Now, they might agree or they might not agree with the proposal or the interpretations that the ICRC puts forward. I would say largely the interpretations reflect what we have found in state practice, in jurisprudence, etc. So it's largely consensual. And I think the other thing that's important is that international humanitarian law is a universal body of law, and the Geneva Conventions have been universally ratified. And so for us, it was important also to translate our commentaries into the most languages possible. They are being translated into all languages of the United Nations. It takes time. The first Geneva Convention commentary is translated into all of them. The second into, I think we're still missing Arabic. The third one has now, the third Geneva Convention is now out in, the commentary, is now out in Chinese, in English, and in French, and the Russian and Arabic are still coming. And for instance, when the conflict broke out in Ukraine, the Ukrainian government requested us to translate some of the commentaries to some of the articles into Ukrainian so that they can use them better in their, by their authorities. So I think it's meant to be a tool for the parties to use with the most explanation references possible to make them useful for them as practitioners.
Thank you. This is very, very interesting. Let me build on this a little and maybe ask you more of a personal question, maybe. In the sense, I'm very interested to hear your role within the ICRC as a legal advisor. How does your day-to-day look like? If there is kind of a general example, maybe. But I'm interested just to see what your role is in the ICRC and maybe drawing also on your current work. What are the most difficult questions you think that ICRC is grappling with today? Whether, and this is a general question, so pick, some of the issues that maybe you want to address, but is it classifying conflicts or ensuring civilian protections, interpreting the rules on conduct of hostilities? Where do you think is the more, what are the maybe most difficult or the questions that you are dealing with most at the moment?
I mean, we have a very broad range of activities, and what you do as a legal advisor depends a bit on the role. So we have very operational, what we call legal advisors to operations. We have them in Geneva, but we also have them in the field. And so indeed, they are very much occupied with, monitoring situations of violence and monitoring whether they are armed conflicts or not, because that's, of course, the departure point for any dialogue that you will have with authorities and non-state armed groups about the rules that apply. And I would say there, the main issue that you grapple with, particularly in non-international armed conflicts, is very often just the facts and to be able to know the capacities of groups, the structures of groups. So it's very much a factual challenge. And I would say also nowadays, legally, there is a bit of a challenge now about thinking about new technologies and classifying conflicts. What does it mean using only drones, using only cyber operations, etc. So I think we are getting to, what is often called hybrid warfare, where as a lawyer, it's either an armed conflict or it isn't. And so you have to categorize these phenomena into the legal categories that we have. Then we have we have what we call the advisory service on international humanitarian law, which is a service that states in 1995 mandated the ICRC to carry out, which was on the one hand to work for the universal ratification of humanitarian treaties. And so a lot of my colleagues spend a lot of time with authorities and states helping them to ratify treaties and then translating the treaties also into their national systems. So also, for instance, rules on how do you find missing persons? How will you prepare for large-scale detention of prisoners of war if you're going to be in an international armed conflict in the future? And also the incorporation, of course, of the criminal requirements of the criminalization of war crimes and grave breaches into national law. So we have a lot of advisory service roles as well, where we work very much with states. Then what you would perhaps call research, research and development, such as writing the commentaries to the Geneva Conventions. And then there's the whole part on humanitarian disarmament, which is also what the legal advisors in the ICRC do, and is also a very long-standing tradition of the ICRC. In fact, since the First World War, in the First World War in 1918, the ICRC called for a ban on chemical weapons on the basis of what it saw on the battlefield and the suffering of soldiers then, which then later led to the Geneva Gas Protocol, the Chemical Weapons Convention. And so the ICRC has been very involved throughout the decades in humanitarian disarmament. So things like the landmine ban, the ban on anti-personnel mines. And today, one of the big challenges is, and we talked about it already, is new technologies. And one of the things that we are convinced together with many other states is that there is a need now to regulate autonomous weapon systems.
Now, thinking outside the box a little bit, and perhaps this is a difficult question, but bear with us. If you were rewriting the Geneva Conventions today, based on what the ICRC sees on the ground, based on your professional experience, is there one rule or perhaps two rules that you would rethink or tweak in order to, improve them in light of these new emerging trends, emerging challenges? And if there are none, that's okay too.
That is a very difficult question, Milena, because, as a practitioner, it's not that you don't think you would like to rewrite some of the rules, but you sort of almost self-censor yourself immediately because you quickly hit the reality check. So I'll give a bit more of a broader answer, perhaps, than just one or two rules. There are rules, I think, that would benefit from rewritings. I mean, take, say, Article 23 of the Fourth Geneva Convention, which restricts humanitarian relief to a limited number of situations for a limited number of people, children, women, pregnant women, and for a limited number of relief items, and subjects them to a lot of, quite serious control by parties to conflict. It was then, though, you wouldn't write it like this today anymore. It was superseded, though, I would say, by Article 70 of the additional protocol, which today is seen as customary and which enlarges very much humanitarian relief already for all civilians, not just for situations of siege, etc., etc. But I think if you were to rewrite a rule on humanitarian relief today, you would just think about what is needed for people to live in dignity and to get the basic needs, needs covered for them. And this is how you would write the rule. You could also, I think, rewrite the rules on internment, which are very, very large for civilians. But ultimately, I think for many of the rules, it's much more a question of, as we said, the rules haven't stood still. They have been interpreted. But the interpretation is, of course, always subject to contention, often by a small minority of states, but still. And so if you think about certain rules, you wouldn't perhaps rewrite them entirely, but I think you would tighten them in order to prevent abuse. So, for instance, on internment of civilians, you would write more clearly what are the procedural safeguards that you need to prevent abuse from these rules that are still fairly openly written. If you were to rewrite the principle of proportionality, which is, of course, a very difficult principle, perhaps you would write more clearly that the incidental harm to be included is not only the direct effects, but also the foreseeable indirect effects. And so if you made that explicit, it might help against the minority of actors or states that still don't accept this. If you were to rewrite the rules on the environment, you might say more clearly that the environment is civilian in nature. And perhaps at the more far end of this, I think you would, would you today not think about what is the limit of what we call incidental civilian harm and what is excessive? And when does extensive, as we see today, overreach the limit of what is excessive? And when is this extensive civilian harm not just incidental anymore, but deliberate? And when you look at today's conflicts and the extensive, massive civilian harm, the entire framework on the rules on the conduct of hostilities, all of which are written to spare civilians from the effects of military operations, are turned on their heads because the majority of victims are civilians, when that is not the idea. The idea is that this is the exception and it can only be incidental.
Thank you, Cordula, for this very, very thoughtful answer. And in fact, you spoke about today's conflict, and I would like to ask you about that specifically now. So talking about today's conflict, you mentioned Ukraine, there's also Gaza, Iran, and so many others, unfortunately. But the ICRC operates in very different legal and political environment. Can you tell us a little bit on what are some of the challenges that you face and how you can ensure that the Geneva Conventions continue to be applied consistently? And in that sense, how can you avoid fragmentation?
I'm not sure fragmentation is really the issue. You know, when you look at all these different conflicts from the perspective of the victims of armed conflict, they don't look so different. You know, you have extensive destruction of civilian infrastructure. You mentioned Gaza, Ukraine, Iran. Look at all of them. You know, the infrastructure destruction is not so different in all of them. The widespread death and injuries of civilians is not so different in all of them. The huge amounts of missing persons that we have, both in the Ukraine-Russia conflict as well as in the as in Gaza. So they are political. All of them are different political contexts, but the humanitarian issues are always the same in all conflicts. You know, from the perspective of civilians or the relatives of missing persons. They can be soldiers, they can be combatants, they can be civilians. And it's more a question of, you know, consistent misapplication of international humanitarian law rather than fragmented application. So what would your, I almost want to put the question back to you. I feel I haven't answered it because perhaps I don't really see what it is you're worried about.
Well, the issue to me is more the question of like the universal application, and I think you replied actually very well to it. So I'm happy, you know, that I think your answer is a good one. And of course, I mean, what we want to do is to avoid civilian casualties, civilian sufferance.
Mm.
Well, shall we perhaps we can move on to the following question because I think you have answered very well previously. Relatedly, are these rules, these international humanitarian law rules, appropriately translated within national legal regimes? For example, many national prosecutions are taking place in Ukraine and other places as well, and it is possible that we will see future national level prosecutions of international crimes where these international humanitarian law issues are implicated. Can the ICRC or perhaps other international bodies work with these national jurisdictions to ensure that they're consistently incorporating and applying rules of international humanitarian law?
Yeah, very much so. And I think you really touch on a critical issue, which is that international humanitarian law respect starts at home. And I think the whole edifice of international humanitarian law and the Geneva Conventions, although it does incorporate very important rules on accountability and criminal accountability, is based on preventive action. The idea is to disseminate international humanitarian law in the whole civilian population. So that's actually incorporated, that's an obligation in the Geneva Conventions, to train your armed forces in order to respect international humanitarian law and to incorporate the rules of international humanitarian law into your systems, into your laws, including your criminal laws, and to to bring it to your courts in order to uphold it. And so, yes, the ICRC does a lot of work with, particularly with parliaments, in order to incorporate the rules. We also have, like other actors, trainings for judges, for instance, or prosecutors in order to, raise awareness, perhaps, for international humanitarian law and the issues that can arise there. Sometimes you have, of course, complex legal questions. We have a dialogue with some of these courts when they discuss issues of international humanitarian law. So all of this is sort of this long-term work that I think ultimately is the only way to strengthen the systems to such an extent that when war breaks out, not everything breaks down, you know. And it's a very long-term endeavor. Again, the ICRC is not the only actor. There are many other actors also that do a lot of efforts in this respect. But it's often sort of behind the scenes. It's not the flashy issues, but it's absolutely needed.
Thank you. Thank you very much. I want to follow up maybe with what you said before, but also that we mentioned a couple of times already. So we know that the Geneva Conventions are one of the most universally accepted legal systems. But then at the same time, unfortunately, we see the violation among, in today's conflict, and we mentioned some already. So I wonder, and I want to be constructive. I don't want to be provocative, but I want to be constructive. And I want to ask you, what is there to be done? Of course, the role of the ICRC is a fundamental one. But do you think the real challenge is a lack of compliance, a lack of enforcement? And what can we do in the future to ensure that the legal, regimes that, of the Geneva Conventions are respected always?
Yeah, I mean, I think that is the most important question, Chiara. And when you asked before, what you do as a legal advisor at the ICRC, I think we ask ourselves this question every day, and we're constantly asking ourselves, well, but the discrepancy between the rules and what we see, the reality on the ground is so huge, Is it a problem with the rules? And I think when we are, we do ask ourselves this question, but we always come with the same answer, that the problem is not the rules as such, but the lack of respect. And you ask, is it a lack of compliance or a lack of enforcement? I think it's both. And so what can we do? And I think, again, prevention is, I think, the first thing that we have to invest much more in. And we have seen you can see that prevention yields result when it is done seriously, long-term, and with authorities that are committed politically to international humanitarian law. That perhaps leads me to the second aspect, which is the political will. At the end of the day, all international law, not just international humanitarian law, cannot be enforced by a police force. And so it relies on the political will of sovereign states, also non-state actors, but let's talk about states for a minute, to commit to it and to abide by it. And the Geneva Conventions, in their common Article 1, are very clear that the idea behind them is that states have to respect international humanitarian law in their own jurisdictions, but they also have to ensure universal respect for international humanitarian law by all parties to armed conflicts. And this obligation to ensure respect requires them to use their influence in order to get parties to conflicts and states to come to an attitude of respect for international humanitarian law. So if you will, it's a horizontal enforcement mechanism amongst equal sovereign states. And I think it's not such a coincidence that you have really quite a few cases in front of the International Court of Justice that turn around this question of ensuring respect. The Nicaragua case, and then, of course, the several cases and advisory opinions around Israel and the occupied territories. And the Genocide Convention case, in a way, is not so different in its approach about, prevention and ensuring respect. And so I think we have to hold states much more to this obligation to step up, to take responsibility not only for what happens in their own jurisdictions, but what happens around the world, which doesn't mean to say they are legally responsible for what another state does. That's a matter of the law of state responsibility in a way. But there is a really profound philosophical argument to say these are what we as lawyers call erga omnes obligations, and they're erga omnes obligations because our humanity as a whole depends on them. And so one of the things that we did about this recently is we launched this, global initiative to galvanize political commitment to international humanitarian law. And the title, which admittedly is awful as a communication title, still is meant to convey exactly that, is that we need to get states to have more political commitment, and we need states to step up. And we have now over 100 states that have joined this initiative, which is, I think, very encouraging, because what it shows is that states, the great majority of states, are not happy to see, the rules being so badly disregarded. And of course, there's what is sometimes called unequal indignation or selective indignation about the violations. But in a way, all states, I think, have an interest and do want to see these violations come to an end. Also because both the political cost, the social cost, but also the world economic cost of violating international humanitarian law is something that the world cannot sustain in the medium and long term. It's just not sustainable. And so we really hope that states will step up politically in order to come together and stand up for these rules, and to reverse the trend that we see. It's a tall order, I know, but there is no other way than to do that. And what I observe personally now, and this is worrying me, is that I feel that states at the moment feel that the political cost to defend international law and international humanitarian law is high. And I want to say to them that could be, in the short term, there might be a political cost to step up for international humanitarian law. But in the medium and the long term, the cost not to defend international humanitarian law will be much higher.
Thank you so much for that answer. Now, allow us to ask one last, perhaps, a little bit controversial question as well. Much of the ICRC's most consequential work happens confidentially and oftentimes without public attribution. Do you ever worry that this necessary discretion comes at the cost of shaping the public narrative of international humanitarian law, leaving space for others, perhaps less legally grounded interpretations to dominate?
That's a good question, and I would say you can't see. I mean, we wouldn't see our activities in isolation. There's room for so many actors to defend international law and international humanitarian law. The ICRC has this very particular, confidential and bilateral way of working. But it doesn't also mean to say that the ICRC isn't very vocal about our interpretations of the law. The ICRC is never confidential about our interpretations. And so I think that between, our commentaries, the report on challenges to international law in contemporary armed conflicts that we put out every 4 years, we've, we defend, I think, a good faith application for international humanitarian law without necessarily needing to say that this or that actor is violating it. So I think there are ways to defend the good faith interpretation of international humanitarian law without pointing fingers. And that said, there are other actors that I think do that very well, and make it very concrete sometimes to speak out about specific violations, just also and this illustrates, it brings it close to people to see what it means when international humanitarian law isn't respected. And so I think there's place for all different actors to defend international humanitarian law. And while there are certainly also loud voices with whom perhaps we would disagree, I think our task then is not just only to speak louder ourselves, but to give more voice to all those who are perhaps less heard around the world. Or to listen more.
Thank you so much. Thank you for this lovely conversation. To wrap things up, thank you again so much for taking the time to join us today, and thank you for sharing your insights on these very important issues. I've really enjoyed our conversation, and if our listeners have too, you can join us on the first Monday of every month for more international law chats. And as always, thank you to our amazing podcast producer, Freya Dowdy-Wagner. Thank you.